So now we move on to defenses. So topic 8.
It's 8 o'clock.
Extreme provocation. And importantly, this only applies to murder. Very important. Only apply to murder. And there is a reform from 2014. It changes provocation to extreme provocation. Therefore, you mostly see cases before 2014 only talk of provocation. But then, because of some cases we will discuss later, it changes provocation into extreme provocation.
In order to hold, in order to be acceptable. You can raise anything you like, but in order to be acceptable to help you, whatever you claim, needs to be extreme provocation.
And when you talk about provocation, make sure you mention section 23. Then, after the reform, it becomes section 23A. Now, I can tell you roughly what's the differences. In section 23 and 23A, very similar. So 23 is provocative act is recognized by law. An ordinary person in the position of the accused could have lost self-control. Importantly, the word is lost self-control. And the accused killed victim as a result of loss of self-control. So it involve objective and a subjective test in it. So again, there is a provocative act that caused an ordinary person in the position of the accused, which is subjected, to lose self-control. And the accused killed victim as a result of lost self-control. This is provocation, section 23. When it reformed to section 23A, which is extreme provocation, the differences is the conduct, which is the provocative conduct, has to be a serious indictable offense. Then the other things are the same. The only differences is the act, the provocative act, has to be a serious indictable offense.
Which it means?
And serious indictable offense is defined in section 4 of the Crimes Act, which is an offense that has a punishment of 5 years imprisonment.
Or above. So like including stalking?
Yeah.
What else do you guys remember?
Well, that one is a different act.
I know, but it's considered serious indictable offense. One is stalking. One is, do you remember last example in the class, the teacher was using that a guy
humiliating,
blackmailing, stalking, all are part of serious indictable offense because they are punishable for 5 years and more. And not every excuse is acceptable to help you with self-defense. You can't say a person lunged at me, that was provocation. Or send me something about my mom or my sister, that's provocation. It must be serious indictable offense to cause extreme provocation.
Okay? Alright, now, what I've got here is the key case for talking about provocation is Che. Anyone remember what Che?
Che.
The husband physically assaulted her.
And? Yes, so he has a long history of domestic violence. And he cut the throat and chopped the husband with meat cleaver.
Meat cleaver. I remember the meat cleaver.
Yeah, just remember the meat cleaver.
And why this is so important? Because 23A subsection 5, yes?
Why is that? Why is that?
It removes the time because previously it was male dominant law, which provocation or extreme provocation must happen immediately after extreme provocation or provocation. Immediately. which in this case judge goes and talks about steamers, slow steamer, which what it's
It
saying,
was a reaction to a build-up
Yes.
of events.
most of the
period of
time
time.
it's saying mostly females, they are not like male, immediately go ballistic and respond to provocation or extreme provocation. Mostly for females, it builds up. So it's not a revenge. Before they were saying it's an act of revenge, that's not gonna help you with provocation because there was a time gap. Now it comes that no, in some female mind, provocation can take time to burst. That's why it becomes important. Because it was previously male dominant rule, now female mind became valuable in this.
What was the section that was under?
I think it was 4.
Section
Subsection
24, 23, 4, I don't know.
Yeah, I've got section 23.
So definitely it's section 23, but maybe it's under subsection.
Under
Subsection, if I think I remember it with 4.
Yeah, it's section 23, subsection 4.
And yeah, so it just says the loss of self-control was led by a long period of abuse, not guilty of the offense, because they can use provocation.
So it's not a revenge anymore.
It's a lead up, and that caused the person to
Lose
lose,
self-control.
to lose self-control. Then the next one you look at is the ordinary person test. Now, can you think of why it says the ordinary person test in green case?
Green case was, which case was?
That was the one with the the 2 males, the non-sexual.
Non-violent.
Ah, yes, non-violent sexual advancement. Yes. Yes.
I've got my note here, that's
Yes.
hard. I wish I could repeat.
So the test is you must consider the cultural background, gender, age,
Personal characteristics.
yes, personal characteristic when you do the objective test. Not every man on the street is not going to represent as a fair objective test. And then you're going to say, would a reasonable person with similar characteristics would respond to the provocation as this defendant did?
Is the green case the one he touched
Touch the
he
leg.
lies down beside and touch the leg?
Naked, lie next to him.
Okay.
And importantly, this case lead to the reform. Why is that?
Justice Kirby.
Why?
Well, he said that there is nothing wrong, or there was nothing technically wrong in a person making a non-violent sexual advance.
And also he was saying that based on modern time now, homosexual is just normal.
Yeah.
Just simply touching a leg is not gravity enough for the person to kill,
To lose self-control.
to lose self-control,
To
to
lose
kill.
self-control.
And that's why, because of her descending judgment, it comes the reform.
So the green case is the one for the reform, is it?
Sorry?
Is the green case the one that caused the reform?
That caused the reform. Because now here, section 23 subsection 3 says 3 types of action cannot be extreme provocation. Number 1, non-violent sexual advance, which is the green case. Number 2, inciting disease as to provide excuse for violence. That's Kenny case, which is not listed in here.
Means you cannot fabricate it.
Yes.
And you can fabricate, do whatever you like, but it's not going to help you if you fabricate the provocation in order to have an excuse to kill the person.
Yeah, because in Kenny case, he self-induced, and then he made up whatever reason, provide an excuse that he says that, as you said, he fabricate and to say that he lost self-control and need to kill that person. So you
What's
cannot.
the third one?
Number 3, mistake. Deep case.
Is that the which case? Deep case. Is that the one that two brothers, the one brother comes and kills the person, then they realize the other person was the one who was provoking his brother?
Yeah.
Could you tell me a little bit more about that? Is what you know?
So deceased was one of the group of men who was invited in an attack on the defendant's brother, and he was thinking that the person that was killed, the deceased, was the person that doing the provocative act, but it wasn't. So it was a mistake.
So brother thought that other brother
Other
would
person,
say A and B.
other person of the gang.
There was a gang who was doing something provocative
Yeah.
to his brother.
Yeah.
Then he becomes heroic, goes and kills the person. Then he realized that he killed the wrong person. And he raised the provocation, and judge said that's a mistake, it's not gonna help.
Yeah, but he says cannot rely on that mistake as an extreme provocation. So again,
this is exactly what was in the exercise in the last session in our criminal law lesson. The person perceived the guy who is walking on the phone is mistakenly and he killed. So he cannot raise he can raise provocation, but it's not gonna help because provocation by mistake, deep case, is not gonna help.
cannot be extreme provocation.
So we will approach that one by this deep case, provocation by mistake is not gonna help if he raised.
But why do you think it would be considered provocation? Because he was just following him.
No.
Following him.
He says this guy, he mistakenly assumed the guy who in the dark walked toward him is the same guy who threatened him.
Has been harassing him, has been giving phone calls.
That was in that, you're talking about the sample question.
Yeah.
That was in that sample question.
I know, but I just don't understand why it would be a provocation.
Now, because when the person...
I wouldn't think it was going to be a provocation there.
If I'm calling you, if someone is calling you, I'm gonna kill you. You go outside to put your rubbish, and someone from dark says,
"Oh, I'm gonna get you
here
now."
I'm gonna do what I promised you to do, and he's coming toward you or toward your kids. What are you gonna do?
So he thought
the guy that was
the
coming.
same person on the
Okay.
phone.
And he lost self-control and going to attack that person.
Okay.
So he
Under
can raise
extreme
the provocation by mistake, but it's not gonna help. Why? 23, section 3.
23 subsection 3.
Subsection 3 of the crime.
And I've got here written there are two limb tests for the provocation. First limb is gravity of provocation,
Oh, yes.
and second limb is the reaction of the defendant.
So that's what it says, excessive provocation, gravity.
So regarding to the gravity of provocation, we're a reasonable person in the position of the defendant, same personal characteristic, age, sex, maturity, ethnicity, background, whatever, would have regarded that gravity.
If someone tells you, fuck you, and you kill the person, gravity test is, would a reasonable person with the same characteristic, if someone told him, fuck you, would go and kill the person? Is this provocation is so heavy that is it considered extreme provocation?
That's first
This
limb.
is the test.
Second
Answer is
limb,
no.
and second limb is the reaction of the defendant in response to the gravity. Would a reasonable person, same thing as the same age and maturity of the defendant, will form an intent to kill or cause grievous bodily harm?
Wilson case, the annoying person, gravity, annoying doing what he did, was it enough provocation to kill? Gravity of what he did in that annoying case, Wilson. Answer is no. Second, would a reasonable person with the similar characteristic or same characteristic would kill the person for doing what he did? Answer is no. You see, you can apply the same test on almost all of the provocations.
And then lastly, you will see there is a Turnbull case.
Oh yeah, that's very cool.
Conduct amounting to extreme provocation. Now, look at the case, the year of the case.
Let's
What
see what
year is
that case is.
2016.
And what does that tell you?
It's only 2 years
After
ago.
extreme provocation.
After the reform. And what is the reform?
Let's say what that case was, the Turnbull. The 2 environmental officers that the one keep going to his property illegally
Farm.
because he didn't consent to start doing stalking and all these things. Then he grabbed to kill one and asking the other one, watch and learn and go and tell the world. So,
Because if you look at the year of the case, it says 2016, right?
Yeah.
And the reform happened in
2014.
2014. So they use 23A, which is the reform,
Yes.
which is extreme provocation. Now, but what is important is it says the act must be, the provocative act must be a serious indictable offense.
stalking is. Was he stalking? Yes.
No.
He was stalking. He kept hiding behind a bush and tree, filming, recording, gathering evidence, keep chasing him.
But that's not the case. He was just doing his
Yes.
His job. That's another thing. But he was stalking.
No.
Okay, he wasn't stalking. What else we have?
No, the court just says that those people,
He was just doing his job.
they are just doing their job. He perceived them as harassment.
Yes.
He
He
perceived
perceived
them as
as they were stalking.
stalking or intimidating him. But the court held that, well, they are not.
His allegations were that they were stalking. The defendant allegation, but didn't hold.
Yes, didn't hold. The court just says that no, they're just doing their job.
Didn't hold because they were legally doing stalking. They weren't illegally
Oh, if
doing
you go that
stalking.
angle.
Yeah.
Illegal stalking is different than legally stalking. His job is to legally stalk. That was his job. At the time, his job was legally stalking, legally going to someone's property secretly, gather evidence.
I remember you were trying to find what would be serious offense, and then you said about stalk. So it'd be stalk, harass, and intimidate.
Yes.
And that comes from Section 13 of the Crimes, Domestic and Personal Violence Act. It defines what do you mean by stalking, intimidating, all this. And another example of serious indictable offense I have here is Section 59, assaulting or occasioning actual bodily harm. That's serious indictable offense as well. Section 59.
Section 59.
Assault, occasioning actual bodily harm.
We're gonna discuss that in assault.
That's in assault, under assault,
Yeah.
yeah.
So let's please leave a note for the one that you mentioned, serious indictable offense,
Yeah.
15, what section was?
Section 13 of the Crimes, Domestic Personal Violence Act.
Yeah, I personally want to learn what is considered stalking, because if we innocently, as a migrant, locals might know it, but as a migrant, if we innocently do those things, and it's serious indictable offense.
Yeah.
So I'm just personally interested to learn what is in there.
Okay, let's conclude topic 8.
That's great.
Whew.
Well done.
Hoo-hoo,
How
high
do you
five.
start it?